There are numerous legal and regulatory issues in relation to Brexit. Here are the top 5 for business to consider. Business should map EEA to UK personal data flows. These are critical. And then ensure that legal safeguards in place should the UK not receive adequacy status or should there not be a grace period post-exit. Legal safeguards include model contractual clauses in contracts and for intragroup transfers something called binding corporate rules. Businesses that operate in the US should also consider that Privacy Shield listed companies should have additional commitments in their privacy policies in relation to transfers of personal data from the UK to the US. Further, business should think about whether an EU representative should be appointed and the implications of UK GDPR following a no deal. In relation to European trademarks, UK government have said that comparable UK rights will be cloned from European trademarks. Therefore, business will need to consider the cost of parallel filings going forward. In relation to pending European trademark filings, business will need to consider refiling these at the point of exit and will have 9 months from exit date to do this. They also have the option of opting out should they no longer require UK trademark protection. A niche point in relation to .eu domains, business should also consider if they meet the eligibility criteria as we go forward. Brexit is requiring business to re-look at their contractual arrangements. This may be because businesses have migrated part of their business to the EU and therefore repapering of contracts is required, or simply because they want to avoid undesirable consequences, such as the contract becoming uneconomic, or a trigger for early termination happening, or that definitions become ineffective as a result of the UK still being defined as being part of the EU, post-Brexit. Furthermore, businesses are dealing with thousands of contracts and therefore are leveraging technology to understand their risk and mitigate the impacts. With Brexit, we lose the freedom of establishment. Therefore, any existing UK holdcos that are holding EU branches will now need to realise that it will be a third country holding those EU branches post-Brexit, and whether there will be any additional compliance obligations in relation to this. Businesses that have European companies, UK-registered SEs, will need to now look to convert those SEs into UK PLCs and look at the UK government guidance in relation to this accordingly. Number 5, regulatory, and in particular, safety marking on goods. CE marking can be found on products including toys, mobile phones, and machinery, and indicates compliance with EU legislation in relation to environmental, health, and safety. Business need to ensure that the correct notified body is providing the CE marking assessment going forward in order to continue to access the EU market. In the UK government have stated that the UK CA mark will be placed on products that want to access the UK market, and business should ensure awareness of this. Furthermore, they may also need to consider a change in designation of status under legislation. For example, is a UK distributor now classed as a UK importer under legislation, and what does that then mean for product labelling? For more insights and updates, visit our dedicated Brexit website, deloitte.com/Brexit.